to the gentleman from Illinois, Mr. Mark Kirk.
Without objection.
I yield myself as much time as I may consume.
The gentleman is recognized.
Members of the House, the measure before us enables the Department of Justice to come to the aid of state and local law enforcement agencies in investigating and prosecuting bias-based brutality and helping defer the costs when they overwhelm state and local resources. And when necessary, and if approved by the highest Senate-confirmed department officials, it authorizes the department to step in and prosecute at the federal level. What we're doing here today is expanding existing federal hate crimes laws beyond the confines of protecting access to a limited set of specified protected activities. What we do is add to the current list of group characteristics deservedly recognized for protection, the reason being due to their well-known targets for bias-based violence. And so we add new ones that are also clearly belong to the list. And this is after careful scrutiny and hearings on this issue. We add sexual orientation, gender identity, and disability. These crimes of violence are directed not just at those who are directly attacked, they are targeting the entire group with the threat of violence. So the groups in the bill differ from other groups that some have been trying to add on, and I understand some of their reasons for that, which do not share the same kind of history of being targeted over a period of time for hate-based violence. Our approach is consistent with a judgment made by the states that have hate crime laws, 45 of them. They have made the same judgment as we have made for federal law, that many groups should be protected elsewhere in the law, not in hate crimes groups. And I close by reminding members that under Lyndon Johnson in 1968, we first started hate crimes bills under the the church arson bills. The president called us into the White House with the governors of southern states to advise them that the burning of churches, the arson, the cross burnings were so out of control in many states that there was no other remedy except that by statute the federal government would have to intercede where they invited them to do so. And from that has grown this bill that has been tested in the Supreme Court and many other lower courts. And so we come before you with a bill that does not encroach upon the First Amendment or the Fourth Amendment or the part of the Constitution that leaves all other powers to the states. And I urge your continued careful consideration of it, and I reserve the balance of my time.
The gentleman reserves his time. The gentleman from Texas.
Mr. Speaker, I yield myself such time as I may consume.
The gentleman is recognized.